This courtroom hearing starts like many others, but within moments it becomes clear this is not going to be a normal case. The defendant identifies himself as a sovereign citizen, someone who believes the law only applies if they personally consent to it. From the very beginning, he challenges the court's authority, insisting he is a living man and not the legal entity named on the paperwork. According to him, punctuation, capitalization, and formatting magically transform a real person into a government-controlled fiction. As the judge listens patiently, the defendant repeatedly questions jurisdiction, demanding proof that the court has power over him. He claims the court lacks both personal and subject matter jurisdiction, despite standing physically in the courtroom and being clearly identified on the record. Each time the judge explains the law in plain terms, he responds with recycled legal buzzwords that sound impressive but carry no real meaning. Things take an even stranger turn when the charge of driving without a license is addressed. The defendant admits he canceled his driver's license years ago, but insists that doesn't matter because he wasn't driving, he was merely traveling. In his mind, this semantic trick places him outside traffic laws entirely. Ironically, this argument ends up sounding more like a confession than a defense. Throughout the hearing, the judge remains calm, firm, and occasionally sharp, shutting down each claim without raising her voice. While the defendant tries to control the conversation with word games and pseudo-law, the courtroom reality doesn't bend. By the end, the judge enters a plea on his behalf, sets a pre-trial date, and releases him on his promise to return. Proving once again that sovereign arguments may sound bold online, but in a real courtroom, they fall apart fast.
Okay, thank you for your patience there. We had a little bit of a kerfuffle. So,
No problem.
recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. Okay. And I'm not, me being a living person, I don't, my name is in proper punctuation. I don't have a all caps name, nor
okay.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction, subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in Commerce. I was I was traveling home.
Okay.
I wasn't doing business at all. And also, from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
At this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity? I don't. Yeah.
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded in with, excuse me, sorry, the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case. That's I needed to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records, not
So
good enough?
whatever documentation you have,
Mhm.
bring it with you to your pre-trial date. That is what I am telling you, yes. So, and again, that court date, June 26th? Okay, will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From
No.
my understanding, that
And
has to be proved before we even proceed with anything else. Am I wrong?
you are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat, duress, coercion of going to jail.
The hearing begins in a way that immediately signals trouble. The defendant steps into the courtroom not as someone prepared to address the charges, but as someone ready to challenge the very existence of the legal system itself. From his first words, it's clear he subscribes to the sovereign citizen ideology, a belief that laws only apply if he personally agrees to them. He doesn't deny being present. He doesn't deny being the person named. Instead, he insists that the court has made a fundamental mistake by addressing him at all. He explains, with complete confidence, that he is a living man, not a legal entity. According to him, the name written on the court documents, especially because it appears in all capital letters, represents a separate, state-created fiction. In his view, punctuation and formatting are not clerical details but powerful legal tools that transform humans into corporate vessels owned by the government. He argues that because of this, the court has no authority over him. The judge allows him to speak, listening carefully while he delivers a monologue filled with buzzwords like natural person, flesh and blood, and secured party. Each phrase sounds rehearsed, as if memorized from online forums or social media videos promising secret loopholes in the law. He pauses often, expecting the words themselves to carry legal weight. They don't. The judge calmly responds, explaining that none of these arguments change the reality of the situation. The court's jurisdiction does not hinge on capitalization, punctuation, or personal belief. It hinges on facts. He is present. He has been identified. Charges have been filed. That is enough for the court to proceed. But the defendant refuses to accept this explanation. Instead, he circles back again and again to jurisdiction. He asks whether the court is operating under common law, admiralty law, or some undefined hybrid system. He demands proof of authority. He insists that without his consent, no proceedings can lawfully continue. Each time the judge answers him directly, he interrupts with another question, another technicality, another attempt to derail the process. When the issue of the charges themselves finally comes up, the tone shifts slightly. One of the charges is operating a vehicle without a valid driver's license. The defendant does not deny that he was behind the wheel. In fact, he openly admits that he cancelled his license years ago. But in his mind, this admission doesn't matter, because he claims he wasn't driving. He says he was traveling. This distinction, he believes, places him outside the reach of traffic laws. He argues that driving only applies to commercial activity, and since he wasn't being paid or transporting goods, the law doesn't apply to him. He presents this argument with absolute certainty, as if it's a legal trump card that will instantly end the case. The judge lets him finish, then calmly explains that the law does not recognize this distinction. Operating a motor vehicle on public roads requires a valid license, regardless of intent, commerce, or personal philosophy. By admitting he cancelled his license and still chose to operate a vehicle, he has effectively confirmed the basis of the charge against him. Unfazed, the defendant returns to wordplay. He claims he never agreed to any contract with the state. He says licenses are voluntary. He argues that laws are offers, not obligations. Each statement is delivered with the same confidence, but none of them slow the proceedings. The judge continues methodically, clarifying that participation in society comes with responsibilities, whether he agrees with them or not. As the exchange continues, frustration begins to show, not from the judge, but from the defendant. He repeats himself, raising his voice slightly, emphasizing words as if volume might substitute for legal authority. He insists the court record must reflect his objections. The judge assures him that it does, then moves on. At one point, he refuses to enter a plea. He declares that the court has no standing to ask for one. The judge explains that refusing to plead is itself a choice, and the court will enter a plea on his behalf. She enters a plea of standing mute and continues without hesitation. Despite the constant interruptions, the judge maintains control of the courtroom. Her tone remains firm but composed, occasionally sharp when necessary. She does not argue ideology. She does not debate internet theories. She focuses on procedure, law, and reality, the three things sovereign citizen arguments consistently fail to overcome. As the hearing approaches its end, the judge sets a pre-trial date. She explains when the defendant must return and what will happen next. Even here, he tries to object, questioning whether dates themselves are valid without mutual agreement. The judge ignores the commentary and completes the record. In a final act of restraint, she grants him a personal recognizance bond. He is released on his promise to return to court for the next hearing. No dramatic arrest. No immediate jail time. Just a clear warning that the process will continue whether he accepts it or not. The hearing ends much like it began, with the defendant convinced he has exposed flaws in the system, and the court moving forward unaffected. His arguments, while delivered with confidence, change nothing. The law remains. The charges remain. And the reality he tried so hard to deny waits patiently for the next court date.